Chief Justice, and may it please the court. Good morning. My name is Emma Castro, and in my time before this court, I will address the issue of whether the warrantless search and seizure of cell phone records, including location data, over the span of 127 days violates the Fourth Amendment. This is a flawed question, however, as it is irrefutable that there was no search. There wasn't even a violation. It was simply the company handing in their information to aid in the investigation. To make this perfectly clear, Mr. Carpenter signed a terms and agreements contract given to every phone user that, if read, informs the customer that the information, including but not limited to the data obtained by the FBI, is property of the company, not Mr. Carpenter. It is vital to remember that this is not an app where one may just skip through it and not read it. It's a contract that was clearly outlined upon sale of the phone.
And Counselor, now, are you saying that he was aware of this when he went to Metro to get his cell phone in the first place?
Yes.
Continue.
He signed over his rights when he turned on his phone, something of which we know he was notified. This is not a case about technology or privacy as the petitioner may have you believe. It is about ownership. The company has ownership of the information, and Mr. Carpenter was told this, so he has no foundation for this case.
Counselor, on that same line, the petitioner may say that, well, since they own the phone, they own the rights. Explain to me why that's a faulty idea.
Because Mr. Carpenter signed the contract referred to previously, and in that contract he stated that the information was property of the company.
Okay, continue.
He was made aware that everything done in this investigation is legal, despite what he may claim. He was not actually involved in the transaction of records at all, and if he was, it was a minimal role to play. It was the company and the cell phone tower going through the motions. It was, to put it simply, the transactional records obtained by the government included the date and times of the calls and the approximate locations where the calls began and ended based on their connection to the cell phone towers, cell site information. This is not recorded calls or GPS tracking. The government was not privy to what was said on the calls, nor do we know the exact coordinates of Mr. Carpenter. None of it was collected specifically for helping the police. It was the general locations and
Counselor,
times.
would that information be relevant even today if there wasn't for somebody outside information? You couldn't figure out where he was at unless somebody told where he was at, correct?
Correct.
Okay, continue.
Okay. As it was not collected specifically for helping the police, it was collected for business records. It does not belong to Mr. Carpenter, it belongs to the company. It was simply so they know who to pay. It was business records given voluntarily. That is not illegal.
And so, therefore, Counselor, it's your assertion that they didn't need a search warrant to give, if the company gave away the records in the first place, correct?
Correct.
Okay, continue.
Moving on, even if we are to believe that he owns the information, which is a contestable claim, by giving it his phone number to his accomplice, he relinquished any previous expectation of privacy he had. This is proven, citing Smith v. Maryland, 1979, in which the court stated the difference between disclosing the numbers to a human operator results in the same lack of privacy expectations. He made his number public, so to speak, by giving it to his partner. Once it was out there, it no longer fell under a reasonable expectation of privacy. Therefore, Mr. Carpenter did not own this information, and even if he did, he gave it up willingly.
Okay. The government, in this case, can't protect Carpenter from himself, can they?
No.
Continue.
Furthermore, even if we are to disregard the fact that Mr. Carpenter does not own the data and doesn't measure up to the privacy expectation due to his giving his phone number away, Mr. Carpenter is still not able to make any claims that he had a reasonable expectation of privacy as he is asking the court for today. Citing Katz versus United States, 1967, a reliable and reasonable expectation of privacy is reliant on two requirements. The person exhibited an expectation of said privacy and that society recognizes as so. This is per Justice Harlan's specifications. It's a clearly fine line that our government did not cross, completely obliterating any chance Mr. Carpenter had at a plausible case. He exhibited no expectation of privacy regarding his data, i.e. his general call location, due to the fact that the information is accessible to his service provider, a fact we know Mr. Carpenter is aware of. Everyone is aware of it. If you disregard all previously stated facts, Mr. Carpenter still has no case. All procedures and investigations were done strictly following the Source Communication Act of 1986 and the Bill of Rights as proposed of 1789. The act previously referred to states that the information may be handed in voluntarily if the information was come across by the service provider. The service provider, Metro PCS, is exactly where they got the data. Referring to the historic proposed document from 1789, Matheson states that each person has a right to protect their property and effects so long as there isn't a reasonable suspicion of the fact of the crime. There was a reasonable suspicion as the investigators had been informed by one of the perpetrator's confessions, wherein he gave the FBI some of his accomplices' phone numbers, one of which belonging to a Mr. Timothy Carpenter. Additionally, the terms and conditions contract states that Metro PCS can turn over information if they think that by withholding it, they are not protecting their interests, safety, and property and that of their service providers. If T-Mobile and Metro PCS are owned by the same company and use the same towers, and if the information can stop the robbery of more T-Mobile stores, why would they not hand it in? They are complete liberty to do so. Taking all of this into account, the law enforcement officers have every right to use said information to convict him of his crime. Mr. Carpenter is attempting to pull the wool over your eyes by making claims the U.S. government violated his rights. He's not asking for the right to privacy. He's asking for a breach of contract. This is something that cannot stand in this or any courtroom. Because of these facts, I will ask this court to uphold the lower court's decision. Thank you for your time. Any further questions?
Thank you very much. Second speaker, please.
Your Honor, ready? Good morning, Your Honor. May it please the court. I, Bryssa Rodriguez, will represent the respondent, the United States of America, in the case before the court today. I will expand on the issue where the warrantless search and seizure of cell phone records, which include location and movements of cell phone users, violate the Fourth Amendment. In my time before the court, I will demonstrate that this case did not involve an illegal search and seizure, nor a violation of Mr. Carpenter's Fourth Amendment rights at any time. To begin with, the Fourth Amendment to the United States Constitution protects and grants people the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Note, Your Honor, that the Fourth Amendment dictates that no warrant shall issue but upon probable cause, and supported by oath or affirmation. Your Honor, no one was ever searched in this case, and nothing was ever seized. Cross-applying all of the arguments made by my co-counsel, there was no need for a search warrant to begin with. And taking into consideration the third-party exception established in the case of Smith versus Maryland in 1979, the third-party exception is a standard established by the courts to allow the government to access information that individuals share with third parties without a warrant. The exception applies as follows. A person has a legitimate expectation of privacy and information he voluntarily turns over to third parties. In our case, the FBI obtained business records that consisted of subscriber information, toll records, call detail records that showed the phone numbers of incoming and outgoing calls, which were provided by Mr. Carpenter's cell phone provider.
Counselor, none of these records were of a private nature, were they?
No, Your Honor.
And all the records were actually just numbers or facts to that effect, not conversations, correct?
Yes, Your Honor. This will later be covered under the Smith versus Miller case.
Continue.
Now, Your Honor, it has long been understood that any information obtained from others involved in the crime is viable due to the fact that it was a defendant's choice to disclose their illegal activity or be vinculated within that circle of crime.
How did he disclose?
Well, Your Honor, before the FBI went to the cell phone provider, they obtained a confession from one of the perpetrators of the crime. And in that confession, the perpetrator mentioned Carpenter's name. And that was how they got the first digital breadcrumb to the evidence itself.
Okay, so in those conversations with a human person, he called them after the occurrence of the events that transpired with the robberies, correct?
Yes, Your Honor.
And then they put two and two together to put him near the scene of the crime, correct?
Yes, Your Honor, which is why we asked this court to note that it is not the government's fault nor the responsibility to protect Mr. Carpenter from himself. In this case, Mr. Carpenter made the erroneous mistake to happen to tell his illegal encounters with one of the perpetrators and be involved with one of the perpetrators in regards to the crime. The fact that they were able to say and participate willingly in giving that information to the FBI was simply a right under the protection of the First Amendment, Your Honor.
Okay, now it's kind of interesting. Mr. Carpenter has the First Amendment right to call anybody he wanted to call, correct?
Yes, Your Honor.
So if we stepped in and not allowed him to call, then we would actually be denying Mr. Carpenter's rights then, correct?
Right, Your Honor, as well as violating the First Amendment rights of either the company by denying them their willingness to participate and provide such information for the government, or the accomplice who was trying to get a better deal himself.
Okay, continue.
So as held in Boyd versus U.S. in 1886, the case involved the government requesting private financial documents in connection with fraud prosecution, and the court ultimately held that a physical invasion of a person's property is not necessary for a Fourth Amendment violation. The Fourth Amendment also protects against invasion into a person's private matters. Your Honor, this case does not involve a private matter, and those business records are not Mr. Carpenter's property. They are business records of the cell phone provider.
Right, and they're not private matters, and we know that because the government, the company freely gave them to the government, correct?
Yes, Your Honor.
Okay, so they can't be considered private anymore.
No, Your Honor. And Mr. Carpenter can try to argue that the records collected were out of an invasion of privacy, but this court again should understand that this is not the case. Many, if not all, of Mr. Carpenter's arguments are ex post facto and with the intention to appeal to ignorance. Mr. Carpenter knew from the very beginning that his cell phone provider collected data of its customer for business purposes. He allowed for that to happen the moment he signed that contract and agreed to all terms and conditions. By signing that contract, Mr. Carpenter allowed for the cell phone provider to collect data for their business purposes. And in this case, the cell phone provider used data to comply with the law. It is this simple. Mr. Carpenter is making a logical fallacy of trying to have it both ways, Your Honor, and it cannot be. As the court understood in U.S. versus Miller in 1976, when it set the standard in emphasizing that a court should focus on the nature of the records, not the quantity or sensitivity, emphasizing that a court should focus on the nature of the records, again, Your Honor. So because the nature of the records goes back to the ownership, this means that we were to look at the cell phone provider as the sole owner of such business records. And the court said in U.S. versus Miller that the defendant could not have had an expectation of privacy in the contents of the records, as they were not confidential communications, but negotiable instruments to be used in commercial transactions.
Counselor, a conversation is between two people, correct?
Yes, Your Honor.
And conveyance is how that conversation
Takes place. Yes,
takes
Your Honor.
place. In the Supreme Court, have most of the rulings always been on conversations, correct?
Yes, Your Honor.
Has there ever been a ruling on conveyances?
No, Your Honor. That would be good police work. If we were to look at the fact that the government somehow recorded or had direct access to Mr. Carpenter's conversations, then we would be dealing with a Fourth Amendment issue. But because that never took place, and we only looked at how the business records were recorded and who voluntarily provided it, that being the cell phone provider, there is no case that Mr. Carpenter can make in regards to an abridgment of his rights.
Okay, continue.
So the court said, again, Your Honor, that the expectation of privacy was not applicable in that case, and said that because the suspect voluntarily shared his information with the banks, it led the court to conclude that the defendant did not have a protected privacy interest in his bank records. So again, Your Honor, referring back to our previous arguments, an expectation of privacy cannot be upheld today. And if we were to cross-apply the Smith versus Maryland standard, the court would have to assert that individuals have no privacy interest in the information they voluntarily reveal to third parties. Now, in terms of procedure, Your Honor, the FBI did nothing out of the ordinary. The police used information that was collected by the cell phone provider regularly. Nothing was changed or altered to obtain only records that had Mr. Carpenter in them. The cell phone provider carried on with their usual business, and the privacy of others was never at risk. As opposed to what the petitioner will have you believe, this case is not about technology or GPS tracking, nor is it about the security of its consumers. This case is about the upholding of a contract that was signed by Mr. Carpenter himself, and all of the investigation was simply a product of good police work and the tailing of digital breadcrumbs. And there is nothing illegal about it, Your Honor. And ultimately, as the court in Miller held, the records belonged to the cell phone provider, and they could have denied the government's request like many large companies do.
Now, Counselor, you brought up a good term there, digital breadcrumbs. How is that different than the app that actually follows you along in real time?
Well, Your Honor, because digital breadcrumbs simply follow a trace, an algorithm of patterns and locations and things in regards to signals, it cannot be compared to, for example, a real-time location that would be acquired through a tracker. This never took place, Your Honor. A tracker was never placed on Mr. Carpenter. This was simply good police work.
So, Counselor, you could agree to the fact, you could be assertion that that would be totally way intrusive and could be a Fourth Amendment issue. But
yes.
This is not a Fourth Amendment issue because why?
because, again, Your Honor, it's simply a small trace. It's kind of like a first, how would I describe this, Your Honor? It's not like they're obtaining real-time location or access to where Mr. Carpenter is at all times. It's simply a signal that attracts and brings up the question as to whether two events could be linked based on that one signal.
And it was taking place months after the events of the
Yes,
of said crime, and only after a corroborating witness
was able to provide information.
Continue, please.
So that being said, Your Honor, no one asked for a search warrant, just like no one was searched and nothing was seized. Like the records concerning Mr. Carpenter, the investigation was aided with voluntary intel. In conclusion, Your Honor, having looked at all of the circumstances regarding this case, we ask that you uphold the lower court's ruling and rule in favor of the law. We have demonstrated and shown clearly that there was no infringement on Mr. Carpenter's Fourth Amendment rights.
Counselor, one quick question before you leave. If we decide to vote for Carpenter, what would we actually do with the Constitution, in your opinion?
Your Honor, you would be infringing on the First Amendment. So that being said, Your Honor, you would be violating a constitutional right. So if we were to allow for Mr. Carpenter to walk away with his crimes, we would be tearing apart the Constitution. Because there was no issue in regards to the Fourth Amendment, we cannot create an issue of the First Amendment, Your Honor.
Okay, so constitutionally speaking, you're saying that the only way to uphold in today's between petition and respondent is to vote for the respondent, because you're the only one that actually upholds the Constitution, correct?
Yes, Your Honor. All things being fair, we ask this court to see reason and vote for the upholding of a law. If there are no further questions, I will retire. Thank you.